distinguished guests here in Brussels and those joining us online. It's a great pleasure to open today's discussion on international dispute resolution and especially on the Commercial Court Düsseldorf. This new court is not just a German project. It is a part of a wider question: how can Europe remain attractive for global business and investment? The answer is clear: Europe must guarantee a trustworthy, efficient, and modern dispute resolution system. Today we connect three important ideas: the rule of law, economic growth, and Europe's role in the global effort for justice. Before we start, let me warmly welcome the distinguished panelists who will guide our debate. Mrs. Claudia Juncker, Head of Law and Integrity and General Counsel Deutsche Telekom AG, President of the German Federal Association of In-House Lawyers and Vice President of the European General Counsel Association. She knows what companies expect from dispute resolution. Mrs. Nyosha Basiri, arbitrator and lawyer, co-founder of Arp Boutique, Brussels lecturer in the MITS program, Geneva Master of Laws in International Dispute Settlement. She brings the voice of global clients and legal practice. Mr. Robert Papst, Presiding Judge, Commercial Court, Senate for Corporate Law and Post-M&A Disputes, Higher Regional Court of Düsseldorf. He represents the new court in practice. And Mr. Andreas Stein, Head of Unit Civil Justice from the European Commission, responsible for justice policy, bringing the essential European perspective. And of course, our moderator, Mrs. Catherine Prebull, who will guide us through this conversation. I thank you all for being here. Your collective insights and experiences will make today's exchange concrete and valuable. I would also like to express my special thanks to the staff of the North Rhine-Westphalia state representation here in Brussels and all supporters who contributed to the success of the event. Germany has a long tradition of strong and independent courts. Both our civil court and our commercial court are over 120 years old and still influential worldwide. But we had to recognize that in recent decades, German courts were not the first choice of parties in international commercial disputes. From 1995 to 2022, the number of commercial cases in Germany courts dropped by almost a third. At the same time, arbitration grew in popularity and international parties often turned to London, Paris, Amsterdam, or Singapore. This was a wake-up call for us. To maintain its status as a competitive place for business, Germany must also offer a competitive dispute resolution system. That is why we created the Justice Location Strengthening Act, which entered into force this year. It allows for specialized commercial courts with English as a working language, experienced judges with commercial expertise, modern digital tools and hearing rooms, and procedures designed for complex cross-border disputes. North Rhine-Westphalia was one of the first federal states to act. Düsseldorf, Cologne, Essen, and Bielefeld are now home to a commercial court and new commercial chambers. The Commercial Court Düsseldorf is the flagship. It hears at the party's discretion first instance disputes equal to or above 500,000 euros concerning M&A, corporate law matters, construction, and insurance. It is composed of 3 specialized panels at the higher regional court. It offers proceedings fully in English, if parties wish so. It begins cases with a case management conference to set structure and efficiency. It provides confidentiality. My English is not so good as the English of the court. It provides confidentiality protections and even verbatim transcripts, offers modern, well-equipped courtrooms, and gives, if necessary, judgment that can be appealed directly to Germany's highest court. Briefly, This court brings together the authority of state justice with many features that international parties know from arbitration practice. Of course, success will not come overnight. Trust in the new court must be built step by step and case by case through quality and reliability. One challenge is the accessibility of German law. Unlike English law, it is not always available in translation, and it can be difficult for international users to find their way. If German courts want to be attractive for foreign parties, we need to make our law easier to use through translations, explanatory materials, and digital access. At the same time, I want to stress the value of diversity within Germany. Other federal states, Baden-Württemberg, Bavaria, Berlin, Bremen, Hamburg, Hessen, Lower Saxony, are also creating commercial courts with different areas of specialization. This should not be seen as fragmentation, but as a strength in variety. Together, these initiatives can form a network of specialized courts learning from each other, sharing experience and presenting a united face to the international business community. And beyond Germany, there's a wider European debate. Some speak about the 28th regime, a European commercial law available alongside national laws. Others discuss the idea of a European commercial court. Whatever the outcome, the message is clear. Europe must look beyond national borders and build its reputation as a global hub for justice. This brings me to Brussels and the role of the European Union. The rule of law is not only a value, it's also a condition for growth. Investors will not bring capital to places where courts are weak and judgments unpredictable. That is why the EU has worked to protect judicial independence, to modernize procedures, and to ensure that judgments can be enforced across borders. It is also why Europe is exploring new ideas, for example, the investment court system in trade agreements, and even the idea of a multilateral investment court. The message is simple. Europe must also compete in justice. Just as we compete in technology, in innovation and trade, we must also compete in providing legal certainty and trust. Against this backdrop, Düsseldorf is more than just a local project. It's a prototype. If Düsseldorf succeeds, it will show that state courts can adopt the best features of arbitration, flexibility, confidentiality, case management, while keeping their unique advantages, transparency, legitimacy, appealability, and EU-wide enforceability. If Düsseldorf succeeds, it will show that Europe can offer an alternative to London, New York, or Singapore, a legal hub on European soil shaped by European values. Ladies and gentlemen, today's panel is perfectly prepared to explore these questions. A judge who can tell us about the court in practice, a lawyer who knows the expectations of global clients, an in-house counsel who speaks on behalf of the business community, and a policymaker who gives us the European view. With their insights and under the guidance of our moderator, I'm sure this discussion will be rich and inspiring. The Commercial Court Düsseldorf is still young, but it carries a clear promise to strengthen trust, to serve international business, and to reinforce Europe's place in the global competition for justice. By meeting here in Brussels today, we sent a strong signal. Europe is serious about justice. Europe is serious about competitiveness. And Düsseldorf is ready to play its part. At this point, I'm delighted to invite the President of the Higher Regional Court of Düsseldorf, Dr. Werner Richter, to take the floor and share his introductory remarks on his court and its role in this important project. Thank you very much.
Dear Minister Dr. Limbach, dear ladies and gentlemen, it's my great pleasure to address you today and to take this opportunity to share some more details about our pioneering and forward-looking project, the new Commercial Court Düsseldorf. As the Minister just mentioned, the Commercial Court Düsseldorf is the result of North Rhine-Westphalia's strong commitment to establishing an attractive and competitive venue for the resolution of cross-border disputes in the field of commercial law. A modern state court with international outlook and with global reach. In this context, one might ask, why Düsseldorf? After my opening remarks, we will show a short video with the key local advantages that make Düsseldorf such an appealing choice. Even now, I would like to point out that Düsseldorf is not only the capital of Germany's largest federal state in terms of population and located in the, that's very important, in the economic heart of Europe. It has also enjoyed a special status and strong reputation as a legal venue, particularly in the field of commercial disputes. In addition to its specialization in areas such as corporate law, antitrust law, and competition law, Düsseldorf's expertise in patent litigation stands out in particular. This is not only due to the special competence of the courts of Düsseldorf for patent disputes within Germany. Since 2023, the Higher Regional Court of Düsseldorf has also been home to one of the local chambers of the European Unified Patent Court. A true success, from my point of view, a true success story is confirmed by the high volume of cases. This underlines Düsseldorf's importance in global legal matters. However, not only the location factor serves the important legislative interests mentioned earlier by the Minister. The specific structure of the Commercial Court Düsseldorf also supports the goal of a credible and sophisticated dispute resolution system. 6 months ago, in April, 3 senates were established. Each of them is made up of judges with cutting-edge expertise in their respective fields and capable of conducting proceedings in English. The new proceedings include the option of producing a verbatim transcript. In addition to providing state-of-the-art courtrooms and consultation rooms, the court also offers the possibility of holding non-public oral hearings to safeguard, and that's very important, to safeguard business and trade secrets. Another innovation is the introduction of an upfront case management conference. This new option contributes to the intended increased level of efficiency. Also, unlike in arbitration proceedings, the parties have the option of appealing to the Bundesgerichtshof, the Federal Court of Justice of Germany. Finally, the publication of judgments by the Commercial Court ensures transparent case law that promotes legal certainty. By that, the Commercial Court Düsseldorf combines legal and business interests while preserving the high value of the independence of the German legal system, and the independence of the German courts. In particular, the Commercial Court avoids complexities of special formation proceedings regarding the appointment of arbitrators or judges. It's finally important to note that our commercial court does not function as an opponent or a rival, but represents an attractive alternative to the growing field of arbitration. The opening ceremony in April was a great success. The opening was attended by our Minister President, the Prime Minister of North Rhine-Westphalia, among other representatives from politics, from the commercial sector, and the legal profession. The Commercial Court Düsseldorf received excellent feedback. Just within weeks after its establishment, the Senate for Corporate Law and Post-M&A Disputes, as well as the Senate for Construction Law, received first cases with multi-millions value in dispute. Today, just to give you the most recent status, the Commercial Court Düsseldorf is handling seven of the 11 disputes pending at commercial courts in Germany. The Commercial Court Düsseldorf is still in its early stages. The minister says we are very young. Yes, the court is very young, not me personally. As the business world continues to evolve, we remain committed to continuously developing and adapting our commercial court to meet the needs and requirements of the commercial sector. The Commercial Court Düsseldorf is dedicated to serve as an attractive and competitive option, in particular for cross-border disputes in the future. We, the judiciary, are therefore very interested in exchanging ideas with the key stakeholders, with you, from both the legal profession and the commercial sector, as we have done recently by organizing and joining dispute resolution conferences in Düsseldorf and Frankfurt, in Hamburg, and in Berlin. In this spirit, I would like to thank you very much for your interest in the Commercial Court Düsseldorf. To get a more concrete impression about the new Commercial Court Düsseldorf and its facilities, we have prepared a short video clip. I can promise you, yes, I can promise you an amazing insight into my workplace. I'm looking forward to our upcoming discussion. May today's dialogue contribute to further developing of an effective, top-notch dispute resolution system. Thank you very much for your attention.
North Rhine-Westphalia is the economic heart of Europe. Effective legal protection for companies is crucial for the location and maintaining the region's positive investment climate. The Commercial Court at the Higher Regional Court of Düsseldorf plays a significant role in this. It specializes in complex commercial disputes with a litigation value exceeding 500,000 euros. In 3 senates, highly qualified judges handle and decide on cases arising from company law, mergers and acquisitions, construction and engineering contracts, and insurance law. Modern courtrooms and private meeting rooms, as well as the option of conducting proceedings in English, create optimal conditions. Trade secrets can be treated confidentially. Taking direct action before the higher regional court and the possibility to appeal to the Federal Court of Justice guarantee fast and efficient proceedings and a verifiable decision.
Hier schneiden. So, hello and a very warm welcome also from my side. My name is Katrin Pribbel. I'm the EU correspondent for a pool of German newspapers, including Augsburger Allgemeine and Rheinische Post. I might also be the only non-lawyer in this room, but bear with me. In case you're wondering why we are actually all speaking in English, even though we're 5 native German speakers. It's not only because Brussels is enjoying Denglish so much, it's actually one of the special features, as we've heard, of the commercial courts, that the proceedings can be conducted in English. So we thought it only makes sense to actually speak in English. Before we delve deeper into the discussion, I would like to first welcome also our panelists. It's an expert panelist, I must say. And may I start with introducing Dr. Claudia Juncker. She's the head of law and integrity at the Deutsche Telekom and has been the general counsel since 2010. In addition, like there's so much to say about what you actually do. I don't know, how you're actually doing this. In addition to her current role, she's also the president of the German Federal Association of In-House Lawyers, as well as the vice president of the European General Counsel Association. And she's the head of the legal committee of the Federation of German Industries. A lot of you will know that as BDI. Then we have Nusha Basiri. She's the co-founder of Arb Boutique, an arbitration-focused boutique firm, and is based in Brussels. And setting this up was probably a logical step for the lawyer, as for more than 2 decades, she has acted as arbitrator and counsel in numerous international arbitrations under the major arbitral institutions and arbitration rules. In addition to that, she's an adjunct faculty at Georgetown University Law Center and a lecturer in Geneva at the Master in International Dispute Settlement program. Also, thank you very much for being here. And then we have Dr. Andreas Stein. He's a German lawyer as well and head of unit responsible for civil justice at the European Commission's Directorate General for Justice and Consumers. And after actually practicing as judge for several years at a district court and then at a labor tribunal, he joined the Commission in 2001 and has worked in the areas of private international law, contract law, equality and anti-discrimination law and competition law. So thank you very much for being here as well with your expertise. And last but not least, Dr. Robert Papst. Since April this year, he's the presiding judge at the Higher Regional Court in Düsseldorf, in charge of the Commercial Court Senate for Corporate and Post-M&A Disputes. And prior to that, he was acting as the presiding judge of the Civil Chamber and the Commercial Chamber at the Regional Court of Düsseldorf, with exclusive jurisdiction over all post-M&A disputes in North Rhine-Westphalia with a value above 500,000 euro. And besides that, of course, also jobs, besides like the main position, he's also active as arbitrator in international post-M&A arbitration. Thank you all for being here in Brussels. And let me just start with you straight away, Robert. Before we're going to zoom out a bit and look at broader questions, could you maybe give us a bit of insight of the past months? How is it going so far? You have experienced in practice. What are your first experiences?
Thank you. Do I have to activate?
Yeah. No, I think it actually is on. You don't have
Thank
to do
you,
anything.
Katrin, for this kind introduction. To cut it short, we are quite pleased. As Mr. Richter already mentioned, so far 7 cases have been brought before the Commercial Court Düsseldorf. 5 of them are post-M&A disputes. I'm in charge of them. And 2 are construction law disputes. One of the construction law disputes is a major dispute with an amount in dispute of around 200 million euros. As already mentioned, the first commercial court case arrived very shortly after establishing the Commercial Court Düsseldorf. 3 weeks after establishing the Commercial Court Düsseldorf, the first case was referred to us. And this is, in terms of court proceedings, warp speed. We have already resolved 2 of the 5 post-M&A disputes. And with 7 cases, we are the clear frontrunner among the German commercial courts. And I've already heard from various lawyers that they started to include forum selection clauses designating the Düsseldorf Commercial Court as the court with exclusive jurisdiction. So I have the feeling that we are gaining momentum, and I'm quite pleased with that.
And we will get back to that shortly to actually find out even more about it. But I would like to zoom out for a minute and talk about the relevance of the rule of law, as we've already heard, as a basic requirement for capital and innovation as well. Claudia, in your experience, what role does a predictable legal system play for international investors, for companies?
Before I answer your question, let me allow to say that I'm a big fan of the idea of commercial courts, and I wish them
Is that a warning now?
to be a great success. And I want to cite Mr. Richter, a top-notch dispute resolution. I like that very much. Now I come to your question. Of course, a functioning legal system is of utmost importance. You need planning security, you need investment protection, you don't want arbitrary intervention. And for example, I know we as a company are invested in countries where there is no investment protection, and that is not a nice situation to be in. Nonetheless, that's not the only important element. There are other important elements. For example, we discussed that the general terms and conditions regime in Germany also applies to B2B contracts, or to be a bit broader, too much regulation, too high energy prices, too high labor costs, and so forth. They are also elements in the attractiveness of a place for investors.
Nusha, how do you see it? Like, how do business locations gain or actually lose, maybe even, the trust of the business community?
So first of all, thank you very much to the organizers and to the Landrat Rhine-Westphalia, and congratulations, I have to say, to the Commercial Court in Düsseldorf. I'm coming from Cologne, but I'm very happy that Düsseldorf is a front runner, especially in so very remarkable and competent hands. I think the competent hands in particular are the judges, because that is the number one predictability for international companies as well, to know that wherever they are, just as Claudia just said, it is really, really important to have a predictable system, and that comes with the judges first and foremost. And of course the law plays a role, no doubt about that. But I think if the judges have the commercial mind, then they will also be able to solve the dispute between the parties, especially when they're coming from different countries, of course. So, and that is something that I see that in my practice as an arbitrator as well. What really international clients and companies are looking for is that they have the security that if they go to a certain forum for dispute resolution, they don't get someone who actually doesn't know how to commercially apply the law to their dispute to come to a solution. So that is very important. The law, you mentioned it already about the limitations, or I wouldn't say limitations, even it's maybe too hard, maybe some restrictions when it comes to the terms and conditions application to B2B, but I have no doubt that this will be also solved. And on the other hand, the German law, I think, can be maybe just like Dutch law as well in that respect, be too wide and to some extent maybe unpredictable when it comes to the good faith principles as well for international players. So if they're not really familiar with that.
So, like, just as a follow-up, so you would say there is a certain degree of skepticism from the business community, companies, towards court proceedings, arbitrations, because like you just mentioned, like some challenges.
I think the one skepticism, Robert, you have just taken that away. That's the time. So time is a huge factor for companies, and if proceedings take too long, that is, of course, a big minus point and disadvantage. Now, arbitration was supposed to solve that, and in many aspects it does, but in many aspects it doesn't anymore, because there it is getting also too complex sometimes and too convoluted. The big advantage, obviously, is the cost. So the advantage of a court proceeding is that the court costs are a minimal fraction of the arbitration costs would be. For the arbitration costs, you would pay the arbitrators, you would pay the venue where the arbitration takes place. The counsel cost, that stays. But of course, if the proceedings are shorter, then hopefully the counsel cost will also be lowered. And those, actually, the counsel costs are the highest cost element.
Before I come to you, I would like to bring in the perspective quickly from an MEP in the European Parliament. We want to show a short video message from Daniel Freund, a Green MEP from North Rhine-Westphalia and major critic of the Hungarian Prime Minister Viktor Orban, I must say, because he's quite famous for that. He has been championing the rule of law and independent courts for a while, and I think it wouldn't be an overstatement to say that the question of rule of law in the EU is a matter close to his heart. So please let's watch the video message very quickly. Yes, here you go.
As a member of the European Parliament, I defend the rule of law against autocrats like Viktor Orban. The rule of law is a necessary precondition for a functioning democracy. But the rule of law and democracy are necessary preconditions for economic success. Look at how Hungary's economy has performed since Orban is in power. It's falling behind pretty much all of its neighbors because independent courts are the backbone of a functioning economy. This is why commercial courts are a good idea. Commercial courts are basically an argument for investing in Germany and in Europe. Our rules-based, independent justice system is a strength, and it makes doing business here more attractive. Donald Trump is currently showing the exact opposite in the United States, where you can no longer rely on courts, you spread uncertainty, and that's no good news for business. You might remember that we as Greens, we were critical of the free trade agreement with Canada, CETA, because it had these provisions on outside court arbitration, where companies could sue governments and it would be decided in opaque structures behind closed doors. We fought for public courts rather than private structures. This is basically another reason for the Düsseldorf Commercial Court. It's a public court, it comes with all the reliability and the good name, and public commercial courts are the better alternative to private arbitration courts when companies have to settle possible differences. In the European Parliament, we have simultaneous translation in 24 languages. As a German, I can speak German and still be understood by all the colleagues. But actually, most of the discussion, most of the negotiation that takes place here is happening in English. It's easier, it's faster, it's more efficient, and I think it is excellent news for businesses if they now can speak English in court in Düsseldorf as well. As an investor, I'm sure that makes the region more attractive. It makes our Wirtschaftsstandort stronger if you can do things in English, and actually beyond the courts, public administration in general should take inspiration from that, and it should be possible to do way more procedures in English as well. With all of that, I wish you all the best. Congrats for this big day, and greetings here from the European Parliament in Brussels. Thanks.
Andreas, we've just heard how important the rule of law is. Like, what can the EU, what can the Commission do to ensure, actually, that there's an environment where the rule of law is upheld?
Yes, thank you. Good evening to everyone. Before I reply to your question, I just want to also join the choir of all those who wish the newborn Düsseldorf Commercial Court all the best. I'm from North Rhine-Westphalia myself. I grew up in Bonn. So I have sort of a natural tendency to be more on Team Cologne than Team Düsseldorf, but I will drop all biases and wish you all the best. Coming back to the serious matter and Mr. Freund's intervention, I think we're talking at slightly different levels, and they're all important, but they're different. Obviously, rule of law is a fundamental sort of a constitutional requirement that applies everywhere throughout the whole EU, that is a necessary ingredient for any functioning justice system. Rule of law is the independence of judges, shortly expressed, and where that is under attack, we are in trouble, not only for the business environment looking for the efficient adjudication of commercial disputes, but we're in trouble on a much larger scale. And unfortunately, we're not in a world currently where this is a given, the rule of law, not even within the EU. And that's why the Commission, this is has been one of our priorities for the last years, to play our part in defending the rule of law through all sorts of initiatives, through the rule of law report that we're publishing every year, through cases that we bring before the court where we think there is an infringement of this principle, something that was unthinkable 20 years ago. And this wasn't even a big topic because it was taken as a given that within the EU this principle is established and doesn't need to be specifically defended. Now we're in a different environment, and I think we're doing our part in many ways. And of course, this is also of importance for commercial disputes, because if I am a business and I have a choice between different jurisdictions as to where I want to have my disputes resolved, a member state or any other country in which I'm not certain that there won't be any outside interference, that the judges are not really completely independent when they're deciding this case, I think it's quite obvious that I would rather not go there. And just on a slightly joking side, I don't think there is a project of the Budapest's Commercial Court at the moment that, even if it existed, had a lot of prospect for success, at least at this stage. But of course, also in the international arena, I haven't now done any research on this, but I would be amazed if Hong Kong, which was quite a hub for arbitration and litigation, because it had the independence and the history and the traditions of an independent judiciary in the past, if they haven't suffered from the changes that have taken place over the past couple of years. But I think, and I will conclude on this, of course, when we're talking about the success of commercial courts, to bring this down to sort of a less constitutional level, this is one of the preconditions, but there are many more preconditions for success. And I think some of them have been mentioned. The language is one, but I'm not sure it's a decisive one, because everyone will be able to offer something in English these days. That's not a unique selling point. I think, and I take this also from an analysis of the Dutch Commercial Court, which I will come back to in further statements. They said what they see with their experience as decisive is the access to judges with specific expertise, and it's the processing time for cases. Those are two key ingredients for
maybe,
the success.
Robert, you can step in and actually say what your experiences on that point is, if it's about the specifications, but also maybe, does the European framework basically meet the needs of, maybe the businesses, but also what you maybe would expect from the EU?
The commercial courts in Germany do not aim at any European frameworks whatsoever. So our top priority is to provide litigants with high quality and efficiency. And as Nyosha mentioned, the human factor is key. If you allocate highly specialized and motivated judges to the commercial court is extremely efficient. And this is our top priority. This is, from our perspective, one of the key demands of commercial litigants in Germany.
Nusha, like what expectations do international companies actually have of legal regulation in Europe?
On the legal, if I would maybe pin it down to the legal framework, so I think, and the practical sides to it is that I think I have a little bit of a different view. I think English is actually, the language is a very, unless I misunderstood you, sorry. I think the language aspect is quite important, not only because of the proceedings, but because of the access to the law as well. So Dr. Limbach has already mentioned it. It is really, really important that for a company to, when it ends up in Germany in a commercial court, that it has the legal, the civil code or the commercial code in English accessible, and the commentaries to it, and the jurisprudence to it. And so for every non-lawyer here in the room, one of the most popular German commentaries on the civil code is actually written all in abbreviations. So good luck for a non-native speaker to decipher what the commentaries means. And so that is really something that needs to be changed, I think, and it needs to be changed quicker for Germany as to meet the expectations as a foreign company to actually feel comfortable in the legal framework there.
Claudia, you've got a lot to do with very different companies, like types of different companies. Do the needs of small, or like how do they differ actually, the needs of small and medium-sized enterprises, mid-cap companies, and large corporations?
Yes. In a large corporation, as I'm working in, there's a group of people whose daily job is to do litigation. So you have experts, and they know how to handle a case, and for them it's important that the case is handled with standards they know. For example, case management conferences, things like that. So they expect that. Mid or small companies, they have a complete different expectation. They usually don't have a team doing litigation all day. They are afraid of litigation. It's an incalculable risk. The interests are running high, and then if you're not in the German court system, or in UK it's the same, but if you're, for example, in the US, you will not be reimbursed your own costs even if you're winning. So they try to avoid, if possible, litigation altogether. So for them, the commercial courts might be a better solution, but maybe they will still try to settle, even though they feel they are right, which is a pity. But actually that you see in big companies too, that you settle because it just takes too long. Mm-hmm. We have one court proceeding that is now running for 23 years, and we did offer settlements, but not everybody is accepting the settlement and so forth. So you can imagine, in companies, it's also, things must be closed. There is a dispute out there, but it should not take management attention and time and be in the press for decades. So even if you think you're right, you sometimes have to settle.
You
And
have something.
I hope that
Yeah.
it will all become better.
You have something to add to
No,
that.
exactly. You mentioned settlement, so I think that's one of the real fortes of the German civil procedure system and the German judges. The real training in how to come to a settlement of disputes, because that is. You know better, but that is, and you just mentioned the point about settling the dispute by way of settlement is the best way of actually coming to an end of the dispute resolution. So
I disagree.
you disagree? Okay.
Here you go.
All right, we're going to pick up, but I wanted to say one thing, that this concept of the settlement by German judges, it is so strong that it has also now had a knock-on effect on international arbitration, where often the German settlement approach is actually welcomed and explored as well. And I think what is also very important is that, unlike, for example, in arbitration where you're bound between the two parties that have agreed to the arbitration, with some exceptions, cases like construction is exactly the kind of cases that make really sense in a commercial court to be solved rather than in arbitration, because you have back-to-back agreements, and it's not always the owner and the contractor, but there's also the subcontractor who might be liable for certain parts. So it's really helpful to have that system in place. I'm very pleased to hear that you had already two construction cases.
Yeah, you have something to add to that.
No, I just wanted to agree to both of you. In some cases, settlements make sense. In some cases, a ruling would not deliver any economic benefit to a claimant if the defendant has solvency problems. So that they have to cooperate to generate something to share. In other cases, a claimant has a legitimate interest in a ruling in order to gain certainty. So it depends on the individual case. We want to meet both demands.
Because we're in Brussels, and I know that you know the systems in other European countries quite well as well. Could you maybe just give us a bit of an overview, like what particular challenges maybe arise from, choosing German law, and if you can put it into context, let's say, when it comes to Europe?
I'm not quite sure what you are aiming at.
Well, in Germany, it's a very different system than compared to, let's say, France, where there's one very centralized system. What kind of,
I mean, it's from our German perspective, it's not a challenge. Just to keep in mind, Germany is a federal republic, and the individual states are in charge of the courts of first instance and second instance. So every German state may establish a commercial court, and in addition to that, limit the scope of its jurisdiction. So 9 German states have chosen to establish a commercial court, and 7 out of those 9 have decided to limit the scope of the jurisdiction of their commercial courts. So we have a somewhat broad variety of commercial courts with varying jurisdictions, but this only increases your options from our point of view, instead of having one commercial court only.
Did you want to join that, or because you mentioned actually the Dutch system?
Yeah, first of all, maybe just to clarify, because I was introduced as a policymaker, which is slightly above my pay grade, I guess. But even
well, the Commission,
even just taking myself for one, I think we have no particular policy in that respect for the moment. And the very simple reason for that is that the organization of justice system is a competence of the member states. We don't interfere, and we cannot interfere with the way our member states organize their judicial systems in a federal way, in a centralized way, in any other way. Sometimes we try, In very small areas, we've tried to oblige member states to have specialized insolvency chambers in their courts, but usually you get a bloody nose trying to do that, even for small things. And I mentioned that because when I was invited to this event, I remembered that a few years ago there was a European Parliament resolution on a European commercial court in which an MEP, this is from the year 2018, where a Polish MEP who was very ambitious wanted a European special civil procedural system for expedited commercial disputes that parties could opt into, and as a complement to that, he also wanted to create a European commercial court and asked formally the Commission to put forward a legislative proposal to that effect, and we reacted to that, and I dug up our reaction today, and we said the creation of such courts would raise issues concerning the legal basis, which cannot be easily identified in the treaties. In addition, at this stage, the need for a specialized European court is not sufficiently demonstrated. This may have to be reviewed at a later stage, in particular, and now it gets interesting, taking into account the current attempts by a number of member states to create new courts appropriate for international commercial litigation and the degree of success of those initiatives. And that gives me an opportunity to say that, you know, we have no active policy in that respect, but we observe that this happens in quite a number of places. This happens in the Netherlands. There was even an idea of a Brussels. I haven't heard about that much lately, but there was that project. Of course, Paris also saw a possibility to increase the volume of international cases. So I think there is a market out there, because obviously this is also a market in itself. This is a market for member states to subsidize the judicial system, because you want to attract relatively lucrative cases, even where court fees make up only a small percentage of the overall cost for the litigants, but there is an aspect of income for member states, and of course for the legal environment. It's not for nothing that in London I think there are estimates as to how many billion euros the worth of the legal market there is. So I think we also have to understand this from this market perspective. And all I can say is that I think psychologically it's a bit more difficult to sell yourself in a decentralized system. I think especially if you want to attract non-German companies. German companies, if they're involved, they understand the system. They're dealing with it all the time anyway. But if you want to attract really commercial disputes of a large international scale without German companies involved, then that's just a fact of life.
What does the business side say to that?
I'm not sure whether that is the issue. Why don't we compare traditional courts with the commercial courts? The critique with the traditional courts is that it takes too long, and as I already mentioned, yes, it takes too long. So the promise is it will not take as long anymore. With the traditional courts, and I'm friends with judges, so it's not their fault at all, but they have lack of expertise because they have too broad area of responsibility, Geschäftsverteilungsplan for the German-speaking amongst, and then they have highly experienced
Geschäftsverteilungsplan.
Yes, highly experienced lawyers. So this lack of expertise, I think, will be gone with the commercial courts too. With the non-German companies, there will be an issue still with the commercial courts, but that's not the federalism, I think. It's they think that the German courts will have a prejudice, a bias in favor of the German company. So the home advantage. That is a skepticism. That is currently, I think, one of the main reasons why people turn to arbitration courts, because they can be in a third country. So I don't think it's federalism. What remains an issue is the lack of international enforceability, which is given if you have an arbitration award. Yes, that's about the lack of sensitive company information that still remains an issue with the commercial courts. If the hearings are public and you're a big company like us, there might always be a journalist who's interested in it, and the person has no idea, doesn't have the context, but needs to have some fancy headline, and you can be sure
So
that
maybe I need to step in here now.
90% of what is written there is wrong. Sorry for that.
Yeah,
On court
yeah,
cases.
sure. In court cases,
Not,
yeah.
not on everything, but on court cases.
To build on that, so the I think coming from an outsider's perspective, so a non-German company, I do think at the time of the contract drafting, it has to be clear what the dispute resolution mechanism is. And if the dispute resolution mechanism says court, it's not clear which court. So if it's the model or the clause that is in there would say court, and in this case the Düsseldorf Commercial Court, that's wonderful. If it would actually be a shareholder or M&A matter, etc. But you don't know it. At the beginning of the contract signing, you don't know what the issue and dispute will be. You don't know, you might know the industry, but the legal aspects of it, you don't know exactly. So I would have actually liked to see that the commercial courts within Germany and different federal states would be broader and not super specialized either, because I might have a shareholder dispute, but it has everything to do with insurance. And so to which court do I go then? Is the Düsseldorf the right court, or which one is now in charge of insurance? I forgot, but another one somewhere else in the Bundesrepublik Deutschland. And so it is at that moment quite important to know what exactly the dispute resolution clause should say, and that is part of the predictability factor as well. So that's in contract drafting. Then when it comes to the bargaining power of German companies, I don't doubt it that it is very tough to actually be able to insist on Germany or German law as the law and the forum of the dispute resolution. But I do think that German companies are also in a very good position to push, depending on who's on the other side, of course. So
I will certainly try.
Yes, I know that you try, but I would like to see that even more. Then on the enforceability, when it comes to realistic and commercial court cases, I wonder whether we will have in Düsseldorf a lot of the court cases between a German company and a Brazilian company, or any, Asian company, etc. So is that really the target, or is it not more anyways within the EU? And there the enforcement shouldn't be an issue. But when it comes, of course, to really outside, it's for non-EU parties and a German party, then we have the New York Convention that helps a lot, that is actually the tool for enforcing foreign arbitral awards. And that is something that is missing on the international level for judgments yet.
Robert, maybe you can step into that, or you actually first.
No, I just wanted just one sentence really, because you said a similar system for cross-border enforcement with third states is missing for judgments. It's clear the New York Convention for Arbitral Awards is decades old. Practically every economically important country on earth is a member to that convention, so it's a very well established system that runs smoothly. For judgments, we don't have that de facto yet, but we have a convention. Yes. That we negotiated a few years ago in 2019, the Judgments Convention of the Hague Conference. Yes. And we're hoping that it picks up speed in terms of who ratifies it. We get more and more ratifications in the sort of neighborhood of the EU, the Western Balkans, the UK, not to miss out on that one. That is now our, after Brexit, we didn't have a system of mutual enforcement that was uniform. Now we have it under this convention. And of course, so I'm just saying the situation could evolve in relation to enforcement issues on the basis of that convention.
And it is formidable that this convention has been put in place, but we also see since 2019 it hasn't yet picked up as it was, I think, foreseen. We are talking in comparison to 172 states that are have ratified, or jurisdictions that have ratified the New York Convention. So it's not only the economic powerhouses, but nearly the entire globe. And but I fully agree. I think that's interesting to see which states are actually ratified the convention, the Judgments Convention, and that is very positive. Sorry.
It is what it is. The New York Convention is a selling point for arbitration. Therefore, arbitration and state courts complement each other. But in practice, we have plenty of European cross-border cases where enforcing throughout the EU is more or less sufficient. So we complement each other. And again, kudos to the New York Convention. It's a selling point. Yeah. We are right at the beginning, step by step. We are first aiming at cross-border transactions involving German companies, and those cross-border transactions are often governed by German law. Once we have taken this first step, we can think about competing with the London Commercial Court and attracting international cases without German involvements, but step by step.
And it's not a static system anyway, right? Like it's about maybe like that the whole system is going to evolve in the next months, years, and so on.
To make it clear, we are at the beginning. This is our initial offer, so to speak, the kickoff. There, I can assure you that there will be regular evaluations in order to determine whether or not to optimize the proceedings and or to expand the jurisdictions of our German commercial courts. There will be regular evaluations, and having said that, we also depend on your participation. So please try it out and let us have your feedback. Otherwise, it does not make much sense in investing further resources into our German commercial court system.
You can count on me.
So it's regarded as a joint project as between commercial litigants and your judges.
I mean, what is basically required for parties to actively choose specialized commercial courts? Model clauses. And
yes, but he already promised it. We need a model clause in that we can, that is, so to say, court proven then, that we can put in all the contracts, so that we, when the dispute comes up, that we can be sure that we end up at the Commercial Court in Düsseldorf. Yes, we need that.
Just to answer that, that's also the purpose of today's event. We are not only here to advertise, but also to listen. And I promise that we will publish a model clause shortly on our website.
That's great.
And it's, I can right away say, cite it. It will be quite straightforward. The Commercial Court Düsseldorf shall have exclusive jurisdiction over all disputes arising under or in connection with this agreement, including its validity if the amounted dispute is at least 500,000 euros. Point. And you can add, if you wish to do so, the language of the proceeding shall be English. So that's quite straightforward, and I promise we will publish such a model clause very shortly on our website.
Good point. The language of the proceedings will be English. That's not for the commercial courts to fix it, but the legislator should fix it. The Federal Court of Justice, the BGH, it can decide that even if a proceeding comes in English language, all the documents need to be translated and the proceeding continues in German, which is not a good thing. That should be fixed.
Nyusha, also from your perspective, what role do language, it's one thing only, but also judges, procedural rules, digitalization, play in the choice of a court?
So I enjoyed watching the video of the indeed state-of-the-art hearing rooms. This is, of course, a dream hearing room, and if you have also breakout rooms, that's wonderful to see the live transcription. The verbatim one is extremely helpful and useful as well. The point about if required, requested, and so granted, confidentiality is important, of course, as well. Then what I wasn't able to see on the video is whether there are interpreter booths. So it's a very small thing, but basically if you are dealing with foreign companies, they come with their foreign representatives and they need to have interpretation, and the interpretation shouldn't be consecutive, but it should be simultaneous, and for that you need a special room in the hearing room where you have the simultaneous interpreters there. I think what would be helpful to have actually a centralized, despite the federal approach, a centralized portal where everything about the German commercial courts are mentioned, and also maybe which kind of services, if the parties themselves would need them, could be then also approached. So because, as I said, you come with a foreign party, they have their own language barriers, and the council will be English speaking, that's great, but maybe then between the council and themselves there is a language barrier as well. You want to have interpreters as well. Then you have the full confidential platform for the file, and to which extent actually confidentiality has to play a role. That's again, I think, case by case specific. So that is something that has to be clear. So basically a big D also in the English language for digitalization. That is, I think, the real expectations, especially if you're dealing with foreign parties that are used to a high digitalized standard in their own national courts already.
What can you add to your commercial courts? You can include AI where it makes sense, not, of course, finding the judgment, but, for example, AI can do the transcript. And also we have been using AI in my team now for 2 years. AI is fantastic in doing translations. And I hear that there are now earplugs that can do simultaneous translations. So you're right, English is now important, but eventually this can all be done by AI. And then maybe also the Federal Court of Justice can come along.
First of all, as regards English, I hope that I can convince you that I have a sufficient command of the English language.
No, it was not for you.
I speak plain English, but
it would be less work for you.
AI-based software solutions is a very good point. We are at the moment testing an AI-based software solution for verbatim transcripts, which does not provide an instant transcript yet, it's very quick but not instantly readable during the oral hearing. So we would to have breaks in order to provide those verbatim AI-based verbatim transcripts to the parties and their counsel. And we are constantly reviewing other software-based solutions. For example, a Munich company approached us and will hold a presentation very shortly because they claim they do have an AI-based software solution for instantly readable verbatim transcripts. So we are working on that very intensely. I appreciate this is very much key to the efficiency of the proceedings, because throughout Germany I only know one court reporter who offers instantly readable verbatim transcripts in the German language, and this is quite expensive, and the availability of such court reporters for the German language, not for the English language. In London there are plenty of court reporters for the English language, but for the German language there are not so many. So we are working on that in order to offer efficient and quick proceedings.
So I would not have needed to mention it at all.
It's always good.
Thank you for this softball, so to say.
You had something to add as well.
Yeah, I think on digitalization and AI, of course, those are mega trends everywhere. There are also mega trends in the world of courts and judicial proceedings, and that is one of our focuses in the current mandate, is to help digitalize the justice systems of our member states, at least in cross-border cases, but possibly also beyond that. So I think that's not of course this is important also for high-value commercial cases, but this is increasingly important for every case across the board. So I think this is not a unique issue, but of course when it comes to AI, because you said language will not play a role anymore, of course AI will have a very important support function, and that will become more and more important over the next years. But I think that's not a contradiction whatsoever to the existence of super specialized, super competent judges who speak English, because the human factor in that respect, and someone who can, and it will be a human being who directs the proceedings and makes really a difference also for the attractiveness of the court and the institution, will always be there. So I think those things are true, but in a support function. Maybe if you allow me, because I have spoken about this Dutch report, and I think I just want to advertise this, not for any specific result, but
we're not Rhine-Westphalia then.
No, but because they have a couple of years ahead, and they're taking stock of having tried for 6 years to establish this, and partly, and there are some interesting findings in there that I think it would be useful to take into account from the start, because then some things you don't have to experience yourselves necessarily, you can already take them into account now in order to build your success case, hopefully. And I just want to come back to one of the things that has already been mentioned, and that is the choice of court clauses. Because out of the roughly 40 cases that court has had over 5-6 years, I think there wasn't a single one that wasn't based on a choice of court clause. And of course, parties can agree after a dispute has arisen. They can still say, no, we discuss this now, and why not go to Düsseldorf? I've heard lots of good things about the new commercial court there, but in practice, apparently this does not happen, full stop, basically, with rare exceptions. So the real secret to success is to establish this as something that will be taken into account by, when you draw up contracts, the big law firms, the specialized law firms, that they have you on the radar. when they basically lay the groundwork of what will then happen 5 years later if a dispute arises in that relationship.
Before I open up the floor to questions, I would like to have one final one to you, Robert, because we are here in the North Rhine-Westphalia Landesvertretung, and we've already heard what you're planning to do, what you've already done, but what specific ambitions basically does Düsseldorf pursue on top of that?
Let it put me this way. There is a certain field of commercial litigation where Düsseldorf judges have an outstanding reputation. It's patent law. The Düsseldorf judges in charge of patent law have a fantastic reputation throughout not only Germany but Europe. And we would like to expand this phenomenal reputation to other fields of commercial litigation, for example, corporate law and post-M&A litigation. So this is our ambition, and in order to be successful, it's quite simple. What is within my power as a presiding judge at the Düsseldorf Commercial Court, we have to prove that we are highly efficient and highly specialized and to satisfy the demands of the company. This is our ambition. It's not either arbitration or state court proceedings, commercial court proceedings. Those are two sides of the same coin. Both have their pros and cons. It's a trade-off when choosing. But we want you not to toss the coin, but to choose wisely and to make an informed decision. And if you do so and make an informed decision, either a choice is a valid choice, and we are fine with that.
I would like to open the floor. If you have any questions, please, if you're so kind, and say your name briefly as well, and maybe even who you're working for when it's about Brussels, please.
Thank you. My name is Thomas Wittmann from the European Commission from DG FISMA. And there were some comments which triggered a question from my side. And that was, I think in the introduction, it was said that these courts are to make Germany or North Rhine-Westphalia a more attractive place for investments, and it's important for investment protection. And I think that Daniel Freund, in his intervention, he said that he didn't like this investor to state arbitration under CETA or TTIP, and I think we all remember, or most of us remember, the heated debates about this dispute settlement. Now, I just wonder, and he said, and he pretty much likes your court, this commercial court, because it's not private, it's state and so on. So now I have the question, if I were a foreign investor in Germany, North Rhine-Westphalia, and I had a typical investment protection issue, such as, for example, I relied on a construction permit or a permit under the Emissionsschutzgesetz, which is very important for me, but I don't get it. Or I feel that I'm taxed in an unfair manner or so. Or I feel expropriated or sort of expropriated. Can I turn to your court? Probably not.
No, but
would
that's
not consider it as
an administrative court.
As
not
a commercial matter.
We are only for disputes between entrepreneurs.
Yeah.
We are no investment protection court at all.
And this maybe allow me a second question. Have you ever considered, I mean, within the land to establish also a court or to extend your jurisdiction to such disputes?
That's rather subject to administrative, to public law, and that's not our expertise as the commercial court. So you would have to ask the German legislature to set up a court specific for investor protection disputes. That's none of our business, to cut it short.
Are there any more questions? Yes, please.
Hi, thank you. My name is Julian Rodenbeck. I'm a Counselor of Justice at the German Permanent Representation to the EU. I have the question whether you hope for any positive side effects maybe on the non-commercial sector, namely the regular courts. Like, do you also consider this commercial court maybe as a testing field for best practices for other courts, for example, English as a courtroom language and so on? Thank you.
That's an excellent question. I think there are some elements of the German commercial court proceedings which are also in terms of best practice should be practiced before regular state courts. For example, the case management conference. German courts, commercial courts, must hold a case management conference. Other regular courts do not have to do so. But I heard that first colleagues at regular courts started to offer case management conferences as well, because it obviously increases the efficiency of the proceedings, for example. In this regard, you could regard us as a role model for regular courts.
I've got also two questions from online, and I would actually first say, first one is a bit broader, and maybe like you can, like from your side, your perspective, and also from your perspective, say something to that. How can business secrets be kept secret? What guarantees do parties get?
First of all, we can, under the new section 273A of the German Procedural Code, exclude the public from the proceedings in order to keep business secrets confidential. And we will apply this new provision generously. It's not strictly required that it is strictly necessary to exclude the public. We can already exclude the public if a business secret is potentially involved. So we can apply this new provision quite generously, and some of my colleagues already granted such court orders.
And it sounded like earlier that this is actually
that is
a big point.
That is a big point, and that's very good to hear.
Yeah.
Yes, because our mission is to compete with arbitration, and therefore we will ensure confidentiality as far as possible under this new provision in the German Civil Procedural Code, because otherwise it would not achieve the intended effect.
Can I just say something about the question from the gentleman before about the knock-on effect? I think you answered it very nicely about the courts, but I think the real bigger picture knock-on effect and positive element it has in it is that it starts already earlier in the education, so that the students already are actually encouraged to study in the English language at German universities, that they should not necessarily need to go abroad and to study elsewhere where it is very expensive to study, including the master programs where I'm teaching, but I don't get much, don't worry. But I think that's where we actually have to start, and that's part of, I'm sure also Dr. Limbach's and the ministry's ambition as well, that the universities get involved earlier, that the students get involved, that the referendariat is already, so the German legal training is already partly maybe in the English language, because speaking English, I think Germany is really top. It's great, it's wonderful. There are other maybe neighboring countries that the general population speaks better English, but I think there is a huge difference between speaking language and drafting in English, and that is drafting submissions in English or even drafting judgments in English, obviously, as well. It's a real art. It doesn't have to be neither the very long-winded way that the English judgments are drafted. It doesn't have to be in a way US judgments are drafted. It can be a German judgment, but it has to be drafted just because of the language capabilities in a different way than a German judgment. So it's not just a translation, that's what I want to say. It's a different drafting skill, and I think that you need to learn as early as possible. So that is, for me, the real big picture, huge advantage. And that's what, not only then for the younger generation, but also for entire Germany, a real plus.
And that is, if I may just add a sentence to that, I think that's a bigger challenge for bigger countries. Because if you're in Belgium, if you're in the Netherlands, you're studying law, for example, but not only, lots of things, lots of courses are in English because you know the boundaries of where you operate are somewhat limited, so there's a high likelihood you will have to work and draft and do all of those things in another language, which, as the lingua franca today, is English. And in Germany, it's such a huge country in itself that I think it's not as self-evident, like in France. And I think that's, I fully agree, but I think that's something that still needs to sink in with much larger part of the populations, that basically today you have to grow up speaking two languages, even if you're in the midst of a pretty big country. Without English, things won't work out in the longer term.
There's one more question online, that is directed to you, Robert. Can you shortly outline your Senate's expertise and qualifications?
Yes, and I would combine this with remarks on what the others just said. Before becoming a judge, I worked for 5 years for an international law firm, not only in Düsseldorf, but also in the London office, mainly in the English language, mainly for English-speaking clients. Therefore, I can assure you that I can draft rulings in the English language. I am also active as an arbitrator in international post-M&A arbitration, so I can assure you I can do it. Both my colleagues in my Commercial Court Senate also worked for major law firms and or studied in England and are able to draft rulings in the English language. So rest assured, we are capable of that job, and the courts in North Rhine-Westphalia have such a manpower, also in terms of English, of colleagues who worked for international law firms or studied abroad, studied in England or the United States. We have the human resources. And now that the commercial courts have been established, we can also focus on English skills when recruiting young colleagues. Before establishing commercial courts, there was no reason to consider English skills when recruiting. Now we can also consider that, if a young colleague joins my Senate, me and my other colleagues, we will educate this colleague. So I doubt that this is a serious problem for us. This because we want to provide you with a valid option to litigate in the English language. We did not apply the full scale of potential jurisdiction, but we focused on 3 areas where we know that our judges can do the job in the English language. And we are going to expand this time by time. So it's the first step. It will get better, I can assure you that.
I think this is an amazing word, final word. It will get better, but unfortunately...
Even better, even better.
Even better. Unfortunately, this is all we've got time for this evening, at least on this stage, because I want to first of all, I want to thank all panelists here for this very, very interesting and fascinating discussion. And I want to thank you, of course, for your interest in the room, but also online. We've been given a lot of food for thought, and I'm sure there are more questions and answers. Which you're all invited now to share in a more informal setting over a drink here in the Landesvertretung. Thank you very much once again to you, but also to you, and bonne soirée. Merci.